John Cannon, founder and owner of Cannon Associates, your fierce advocate. In today's video, I'm going to speak to you about federal sentencing and beyond. The first thing to consider in federal sentencing is that it will only take place if you're convicted of a case in federal court. If you choose to contest your charges and you're found not guilty, you're not sentenced. However, the vast majority of people that face federal charges end up being convicted and unfortunately end up being sentenced. So the first step to consider is how you get to this step and what happens at the federal sentencing hearing. Once it is determined that you will face sentencing in a federal court, the federal probation officer is assigned to the case and will begin an investigation. That pre-sentence investigation will look at you, your history, the offense, involved witnesses, and really create an entire picture of you and your history. That pre-sentence investigator will draft a pre-sentence report, which is available to you, your attorney, and the federal prosecutor or U.S. Attorney's Office. All three of the parties will be able to review that, file objections with the federal probation officer, which will lead to that officer drafting a final report. It is vital to work with an experienced federal defense attorney to prepare for these interviews, the meetings, and to respond and draft appropriate objections to a federal sentencing investigator's report. Once that report is finalized, it is submitted to the judge in your case, filed in federal court, and that starts the clock to preparing for the federal sentencing hearing. Once the clock starts for the federal sentencing hearing to be set in front of the federal judge over your case, your attorney and the prosecution may, and in your case should, draft a sentencing memorandum. The sentencing memorandum is an opportunity for your attorney to gather information about you, your life, your family, your experiences, things that have impacted you and led you to the place you're at, to create a story and present that to the federal judge. Federal court is very different from state court. It's not the law and order of just show up and wing it and gunslinging. It is a very high level intellectual process, and federal judges give great weight to the memos and the written briefs that are submitted to the court. It is essential that your federal criminal defense attorney draft a compelling story in the sentencing memorandum to support your case. This will be submitted to the judge and reviewed by the federal judge determining your sentence before your sentencing hearing. Once your case has been resolved, the final sentencing report has been submitted, sentencing memo submitted to the court, your sentencing hearing date will finally come. On that date, the judge will speak to both parties, address objections made to the pre-sentence report, and determine the appropriate guideline range of punishment in your case. The sentencing guidelines is a very technical device used to identify an appropriate or advisory sentence that the court should consider in your federal criminal case. If your attorney is able to articulate well-reasoned objections to different enhancements or aspects in the sentencing memorandum, then you can sometimes have that sentencing range drop down considerably, which puts you in a better place to prepare for the hearing itself. In the sentencing hearing, the court will hear argument from your attorney, from the U.S. Attorney's Office, witnesses, and any other evidence that is presented, and then will deliberate and decide the outcome of your case. It is vital that your attorney is both comfortable and well-versed in appearing in court to be able to argue on your behalf, not only your sentencing memorandum, not only objections to the pre-sentence report, but also the mitigation and extenuation in your life that warrants you being given mercy. The sentencing factors at 18 U.S.C. 355 3A are a vital part of the court's consideration of any variance or any departures or leniency to give you in your case. It is so important that you work with an experienced federal defense attorney that is well-versed in these laws and can fight for you in a way that will be received by the federal judge. At the conclusion of your federal sentencing hearing, the judge will determine how long you'll be confined for. It is so important that you and your attorney prepare for this inevitable outcome and speak about where you would like to be confined. The federal judge will likely make a recommendation for your requested place of confinement that may end up with being where you are housed. There are federal correctional institutions across the United States, and if possible, you may be housed in close proximity to your family or loved ones. When you prepare for and present this request to the court, it will oftentimes be honored by the federal judge. If you have been out of custody leading up to the date of your sentencing, it is important that you and your attorney prepare for the issue of requesting to self-surrender. Federal judges have the authority to allow you to take yourself to the place of confinement if certain criteria are met. When you self-surrender, you would not go into custody on the date of your sentencing. Rather, you would take yourself to the determined place of confinement on a set date and time. This gives you the opportunity to be with your family and address personal affairs prior to surrendering yourself to federal custody. Pursuant to USC 3143A and other statutes, the court can look at this and make a decision at the sentencing hearing whether to give you this opportunity or not. Some of the most important factors that the court will consider is whether you're a threat to the community or whether you're a flight risk. By working with an experienced federal defense attorney, you can craft a well-reasoned argument that you should be allowed to self-surrender to your place of confinement. If you are watching this video, you or a loved one is likely facing federal criminal charges. Undoubtedly one of the most stressful things that you and your family will ever face. We want you to know that we are fierce advocates for families just like you and have walked beside many clients through this difficult time. We hope that you'll visit our website for multiple resources on these issues, and feel free to call us for a free confidential case strategy session where we can talk about a way forward for you and your family.